Welcome back. Now I've been joined by legal practitioner Ehidiamen Destiny. He joins me now to speak on the final addresses and the process so far at the Presidential Election Petition Tribunal. Good afternoon and welcome to the program.
Good afternoon, Mr. Amadi. It's a pleasure.
Yeah, it's good to have you.
To be here.
Yeah, it's been a while. Hope you're doing well.
Yes, sir. Yes, I'm doing very well.
All right. So let's start with basically how you rate how things have gone so far. Just before the program, you were telling me about the 180-day timeline in which things can be done. Do you feel this was a bit quicker than usual?
Well, it's okay. It's a pleasure being here at KAFTAN TV. Though in relation to the efficient rate, the time rate which this presidential election petition is concluded, is due to the issues that were raised. Most of the issues raised in the presidential election petition were issues that borders on law, not merely on factual matters where you lead evidence to prove your case. The issues of whether failure to score 25%, whether non-transmission of result electronically, then the other one, whether the person who is declared winner was validly nominated. These are the gravamen of the whole election petition. And a cursory look at these issues, they are merely legal matters, questions of law. They are not factual matters where you will lead evidence to prove your case. So that's why they are still very much within the constitutional timeline, which is 108. And they have not gone deep into the time. I think it's just between 120 days or 121 days now. So they say have the grace of over 40 days to look at this for the judges to look at this matter meritoriously. That's why it's so fast. Because if you look at Labour Party, they call 13 weakness. PDP, they did not call more than 30 weakness. Then INEC called 1 weakness. Tinubu, the second respondent and the third respondent in each of the petition, they called only one weakness. Then APC as a party did not even call any weakness at all. So these are the things that make the election petition so faster, because of the way the issues that were raised in the election petition.
All right. You know, when you say that the APC did not call or they called only one or thereabouts, is that in any way an indication as to how the case went? You know, people, especially the layman, they will say, "Wow, they have multitudes of witnesses. Do these things count in that regard? Like, you know, the person who has more witnesses has more chances, or no. For the APC not to even, you know, make up."
Like I said earlier on, I said that the issue that were raised were questions of law. They were not really factual matters. It's not the facts are not irreconcilable hostile. The facts are straightforward. Whether a person who failed to score 25% can be declared winner, or whether Shettima was validly nominated as the vice presidential candidate of that political party, which will now make Bola Tinubu a validly nominated presidential candidate of his party. The other one again, whether the failure to transmit a result electronically is factual. Those are the issues. They are not contested about ringing, electoral malpractice, ballot snatching. No, those are not the issue. The gravamen of the whole issue are straightforward issues of law. So in respect of the weaknesses, somebody can call 50 weaknesses. If he has no case, he will lose it. Somebody may decide to, in criminal law, a party can decide to rest his case on that of the other plaintiff.
All right, that's fair enough. I believe. I think the maybe we'll go, you know, through each person's final address and really break down some of the issues that were raised. As one, I think a couple of them in particular have had, you know, controversies surrounding it. But before we go further, you've clarified, or, you know, given that baseline that it's not really about proving, you know, facts, so to speak. There are issues of law.
Straightforward.
So do you suppose at the end of this process, Nigerians can get concrete answers to questions that have bothered them, you know, finally? Issue of 25%. Is there any assurance that at the end of this process, anybody, you, me, the average Nigerian out there, can say, I know for a fact that the court says if you did not win in FCT, it doesn't count. Or the court says FCT is just a state like every other person. If you did not win, get 25% there, it's not a big deal. Can we get concrete answers like that?
You know, and the law is what, according to Kyle Lewin, in America juries, he said the law is what the jury says it is. But many Nigerians have their own view. But some people believe that once the judgment is not going their way, the judge is biased. The law is the law. Lege. That's how it is. The law is the law. In respect of this scoring 25% in Abuja, there are constitutional provisions supporting that you don't need to win FCT before you can be declared. What the constitution requires, that Abuja is a 37 geographical unit. That's the full nation, the country as a whole. With the unit is split into 37 geographical units. Then what is required is that you are able to get 25% in 25 states, minimum. That is the constitutional requirement. And there are judicial authorities to back up this. That's the case of FCDA case, where the judge said that Abuja shall be regarded as if it's a state. It even has a constitutional imprimatur that section 299 that Abuja is one of the states. But like I said, the law...
People who interpreted that, it said treated as a state is not the same thing as being a state.
Like what I've just said, the judges determines the law. But I don't know where a court will now say those people who live in Abuja, their vote is more superior. That may spark protests. You know, people in other places will protest, which means our vote is an inferior vote compared to the people living in Abuja. But like I always say, the judges will determine the law. But we lawyers, some of the lawyers already know the direction of the law in regarding 25% in FCT.
All right, so let's move. Maybe we'll start with Atiku Abubakar's, the PDP's final address. At the end, maybe I'll start with that. It says that the judges shouldn't shouldn't think that because a presidential election has not been overturned, that I think he used the language, the sky will not fall, or not, the world will not end if this is the first time. What do you make of that? Because a lot of people keep saying that when judges want to make decisions, they don't just, I think particularly the Supreme Court, if I'm correct, that is a court of policy or something, or thereabout.
It's a court of public policy.
Yes. So they don't just, just make decisions. They also take certain things into consideration. So is that a factor here at all?
Election matters are sui generis. Sui generis means that it's of its own kind. It's special, it's different from other kind of civil and criminal proceeding. What they are supposed to do now is to look at the laws in respect of the issues that were raised. That is what they should look at. What the major bone of contention is whether non-transmission of results is factual. And APC have responded. If you look at section 135 of the Electoral Act, it said no election shall be invalidated if it appears that it was substantially done in compliance with the law, or the non-compliance substantially affects the result. That word is so simple, which means that even though the thing was not done properly, does it affect the vote? What election petition is concerned about is that whether the votes accrue to you, whether it's your truest votes. That is what the tribunal is supposed to look at. That's the most important thing. But if Nigeria court decides to annul a presidential election, so be it. If they have looked at the matter meritoriously, so be it. So
what are before maybe we'll jump the gun a little bit. What are the implications? We know that for INEC to carry out the election that they carried out, billions, had to be. What happens if the court says, let's do a rerun? A fresh election,
Okay. Okay,
what are the implications?
I will need to explain two things, okay? Because let me tell you, human beings, they wear the sartorial of imperfections. Under Nigeria Electoral Act, they know that anything conducted by human can never be perfect. That's why that one section 135. It said, if it substantially complied with the law, or even though there's a non-compliance, that non-compliance does not affect the vote that was cast to a political party or to a candidate. Now, if the Supreme Court or the APC Court decides today to hold that FCT is mandatory, there we can have a rerun between the people who scored the highest number of votes, which is as result as declared by INEC, will be between Bola Ahmed Tinubu and Atiku.
Every run can only involve two people.
Two persons who score, as in the two people who score the highest number of votes. So it will be between Bola Ahmed Tinubu and Atiku Abubakar. But if the court say that the election was done was not substantially done in compliance with the law, there we can have a fresh election. Do you understand what I'm saying now? So that if the court decides to uphold the FCT, there will be rerun. But if the courts decide to say, oh, the election was not done in compliance with the law, there will be a fresh election. But like I always say, Nigeria election recognizes the fallibility of human being. That human being cannot conduct an activity.
But to what extent?
The extent is to be determined by the courts.
Okay.
In line with the issues raised. The issues raised now, whether they not, that's a factual, what I've said, these are questions of law. They are not factual issues. The court have to determine whether no transmission of result is fatal. Simple as ABC. That's what the court will consider.
Well, I remember when we talked, about the Osun State election, you said, taking some lessons from there, issues of the IREV might not hold as strong water. Of
course. If you look at
and just to cut in, I think I've been to some court judgment or ruling. I noticed that judges tend to, when they are making their pronouncement or whatever, they quote other cases.
Yes.
In such an instance, can the Osun case be something that can be referenced? Wow.
It can be referenced. It can be. Osun case was the first election litmus tested in Nigeria courts up to the Supreme Court in respect of the new electoral enactment 2022. You understand? But the issue of IRF was not raised there. Was not what was there is overvoting and ringing. That was the bone of contention in that place. And the Supreme Court made that if you have to prove overvoting, is the registered voters and the Beavers report, the Beavers report, and the Form EC8A, which is that result that was countersigned by the police and the agent of political parties on the day of election. That is what is most important. But this is a novel issue, whether the failure of no transmission of results substantially affects the election. That's what they call it. It's a novel issue. So first of all, but although it may not be a novel issue, because even the Federal High Court has decided, gave a judgment that it is an INEC prerogative. It is at the wings and caprices of INEC to decide on what mode to collate results. Even the Court of Appeal, just yesterday, last week, it was INEC has the discretion.
But at what point, that discretion, at what point can it be exercised? I believe that before INEC conducts an election, there's a period they release, there's a word for it.
Guidelines?
Yes.
Okay.
After that point, can they decide to do whatever?
You know what? These are matters, intricate matters of law. What the Electoral Act says is if it's done substantially in accordance with the law. Lawyers may come in and say, no, guidelines cannot be elevated into the status of a law. A law is an enactment of the people. It's an enactment of Nigeria through their representative in the National Assembly. Then guidelines are laws made by a body, just an ordinary body. The question between a guideline and a law made by Nigeria, an enactment that has the people's imprimatur, which one will be superior? This is the bone of contention. And again, the other issue they are discussing again, the electoral has the INEC guidelines and manual regulation says that it should transmit result. The question now, at what time will result be transmitted?
There was no stipulation.
There was no stipulated time. And even the result we have now, the result has been uploaded on the IRF, but it was not timelessly uploaded. These are the issue. Is there a lacuna in that electoral act, or can INEC guidelines now be elevated to the status of a law? Those are the questions that the tribunal must come down and decide meritoriously.
All right, I believe that's fair enough. Still on the article final address, it says the 21 states listed by INEC as having been won by Atiku and PDP, they were listed, and article said that INEC on his own averments claimed that he won the states and did not rebut the assertion throughout the proceedings. The tribunal should proceed to uphold the declaration. Okay. So going forward, what do you make of this address and what the PDP is trying to say? And also take note, just to note that he actually asked the INEC, I don't know if it's INEC or the courts, declare him winner, and I think that's something we'll get to later with the Peter Obi matter.
Admission. This is a very, very dangerous. If INEC on their own admitted that the candidate of PDP won 21 states, it's very, very dangerous. But this is an election petition. It goes beyond averment. It goes beyond averment.
Well, I don't know if you can break that word down, just for those who might not know.
Averment means that what you are stating in your originating someone. That's the issues you are the issues you are bringing to the courts, where you state it. It's an election petition. It's sui generis. It goes beyond what is stated in the paper, beyond the averment and pleadings. You must prove your case, because it's a declarative relief. You are praying to this court to declare you the winner. So you must prove it. You must prove it. So the court cannot help you to do your case, because of the case of the defendant is weak. You understand? So you must prove your case, because it's a declarative relief. It is not like a summary judgment, or judgment will be. So it's not like summary judgment or on defendant's list. You must prove your case, because you are seeking for declarative relief. That's why. So that argument, it may go along with, but how strong the evidence, what you have to back up your claim. That's the $1 million question that will be before the honorable.
These are things we hope to get answers to.
Of course.
I'll read another part, an interesting part here. It reads, the petitioners have established that the return of the second respondent as the winner of the presidential election held on 25th day of February 2023 was unlawful and unconstitutional, having not secured 1/4 of the valid votes cast in the FCT, Abuja, as required by the Constitution of the Federal Republic of Nigeria 1999 as amended. Isn't it interesting that this is the PDP final address? Yeah. The person making this or saying this also didn't get the 1/4.
Like what I just explained to you, probably before, if you have, is that if the court uphold that 25% is mandatory in FCT, there will be a rerun between the person declared as the winner. So
is that what you feel he's driving at here?
Yes, now.
I mean, because
so because he will reap the benefit if the court upholds the uphold 25% as mandatory in Abuja. But he will reap the benefit. So if the court is to order a rerun, it's going to be between Atiku Abubakar and Bola Ahmed Tinubu.
But did it take into account that there is there's a third what's the word? There's a third party here.
Yes.
Whatever Peter Obi and his team have put together.
Yes.
What if it ends up, working in Peter Obi's favor? Because it's if someone who is affected by a clause has said the other person is affected, so he should not. He didn't win. Yeah. If it turns out that Peter Obi's petition works out, doesn't that automatically take both of them out? Because it seems like they've admitted.
Of course. If Peter Obi is able to prove his case, that the 600 million, if the court determines so, that the 6 million votes allocated to him were not his truest votes. That he had more votes, he had close to 10 million votes.
And the FCT.
And he had 25%. He will be declared the winner if the court finds out so. Okay? But if on the face of it now, but APC having almost 9 million, PDP having 6.9 million, a Labour Party having 6.2 or 6.1 million, result as declared by INEC. If the court is to wade in deciding whether 25%, scoring 25% of the total vote cast in Abuja is mandatory, it's going to be between Bola Ahmed Tinubu and Atiku Abubakar. These are constitutionally spelled out. There's no law that can bend it. No, this is what is constitutionally spelled out.
All right. So this is. Let's really take a look at the APC candidates' address. First of all, it says what you've said here, that any rerun poll should be between Atiku and I. Tinubu tells court. You know, politicians and will I call them fans and followers? They've taken this to mean that perhaps the president and his defense is afraid of the Labour Party, so they want to make it an APC-PDP affair. But what do you make of some of these statements? Then I'll get to one that people are considering to be controversial. But let's start with this.
Okay. My own is I'm a lawyer. I'm to decide, look at matters of law, matters of fact with law. You know, politics is a very exciting thing. This is the last lap of the political season. The political season starts from the primary election, the election itself, which is the penultimate, before the tribunal. So many parties are still hopeful. Where even though some people, the truth is so clear to them, glaring and staring at their face, they will still decide to manipulate facts to be in their favor as a circle. But in respect of this, like I just stated, if the court were to hold that FCT is mandatory, it means that Atiku and Bola Ahmed Tinubu is going for rerun. If the court finds out tomorrow that Bola Tinubu is not properly nominated, the people that will go for rerun is between Atiku and Peter Obi.
Sorry, just to cut in there, that issue of is it nomination or are you talking about the VP's
no,
alleged
because
nomination?
The VP's nomination is tied to Bola Tinubu's valid candidacy.
Yeah, but hasn't that matter been resolved at the Supreme Court?
It has, but the PDP has raised it again in the court of appeal.
Is that normal? Is that allowed?
Although it's not normal, it's like an abuse of court process. Because the matter is already res judicata, what we call res judicata. The matter need not to be relitigated again because the principle is already set in. But they are still saying no. We lawyers now, we like to explore. That's it. But or if again the tribunal finds out that the purported conviction put forward by the Labour Party and the PDP, or even his citizenship put in forward by the PDP, that he is not a Nigerian citizen, he's disqualified. The people that will come forth for rerun is Atiku and Mr. Peter Obi. Those are the people that will come forth for rerun if peradventure Bola Ahmed Tinubu is disqualified.
That's interesting. But those are for reruns. Assuming it was a case where the whole election has to be redone, is that, the other parties, they are also now back into the field?
Of course, the 18 political parties that contested at the first election will come back and contest again. That's the law.
But what do you think the reality of that is really? We have President Tinubu in power now.
Yes.
If a court says, you are no longer the president, is it a case where he can remain all the way up to the Supreme Court?
No. Yes. He has 21 days to appeal.
Okay.
If the Court of Appeal, which is the Court of First Instance, find him not be the lawful declared winner of the February 25th 2003 presidential election, then he appeal within 21 days. If he does not appeal, he goes home. Then the court will not conduct election, or declare Mr. Peter Obi as the winner if he so merits so, or even declare Atiku if he so merits, or the law support him. That's how it is. So if the court the court, no matter how it turns, maybe it's against Tinubu, he has 21 days to appeal. Upon appeal, the Supreme Court has the constitutional time frame, which is like the Rock of Gibraltar that cannot be moving just by a day, to decide the matter. So no matter how the Supreme Court decide, if they decide in Tinubu's favor, he stays there and complete his tenure, his 4 years tenure. But if they decide against him, he leaves, and that election is conducted, or Peter Obi is declared winner.
That's the place I'm wondering what that would look like. Since it has not happened before, I'm just wondering what could that look like if the president has to step down.
Yes.
Who is running the affairs of the country? And an election is not so easy to, to whip up. Probably they will have to import this ballot papers and do this and do that. So it might take a while. I'm just wondering what's the state of the nation in that regard.
When you say INEC defending their election vigorously, these are the issues they consider, because they know the rigors of conducting the fresh election. That's why the petitioner they against INEC, because INEC is now making some avowment, some facts in support of APC, even though they are not concerned, even though in the issue that concern the candidacy of Bola Ahmed Tinubu, they are in support of it. And naturally these are not supposed to be INEC concern, because they are there to defend the election conducted. So they are looking at when the country economy is dwindling, where with the time preparation for election, the toll on them. These are the issues that INEC is looking at. That's why they are praying that the court should not void the election. Those are the issues they are looking at.
All right. Still on the Tinubu address now, it says in his final address that the evidence submitted and tendered by the petitioners failed to prove claims of non-compliance and corruption capable of voiding his election. But let's talk about the issue of qualification. I've heard legal practitioners speak about will I call it pre-election or
pre-election matters
and post-election.
Okay.
In this case, are pre-election matters still valid?
The thing is only, it's just to and fro. It's to and fro. But people bring in matters which are pre-election in nature. Under the Electoral Act, says that once you find somebody, he lied on oath. If his qualification, he lied as regard to his qualification, you can bring in an action in court to disqualify that person. But again, the Electoral Act under Section 134, it provides grounds for challenging election in an electoral tribunal. Number one, the person did not score lawful majority of votes. The law, it was done without it was done in non-compliance with the law. Substantial, it was not done without, it was done in non-compliance with the law. And the third one that the person so nominated was not qualified to have contested for the election at the time he contested for the election. So the third one, and this is where they are bringing in that he is not qualified or he was convicted. Sometimes they go in Illinois, Chicago. That's where they are rooting it under. So they are still right in law if you look at it, because that section gives them that liberty to bring up these issues.
Right, that's fair enough. When you speak about the disqualifications, I believe recently either the U.S. itself or U.S. agencies spoke about not being able to release the whole facts as are now, and people started to speculate that perhaps the president is an informant or has a deal with the FBI. But these are all speculations.
These are all speculations.
Yes,
and these are media reports. And then me as a lawyer will not dive into that mocking arena. But the issue has taken one issue bordering on his conviction. Even the documents, the judgments, the purported judgment he tendered, it does not pass the test for admissibility if you look at it stricto sensu. Because in Nigerian law, that the foreign judgment reciprocal law, what it says is that if you are bringing forth a foreign judgment, that judgment has to be registered in Nigeria, via motion.
Registered by who?
Registered by Nigeria court. You will bring it as a motion. We're talking about conviction, that there's a judgment, criminal, there's a criminal conviction against a particular person. Before that judgment will not have the sanction and the primatur of Nigeria court. Before that judgment can be admissible. And again, if you look at the Electoral Act, particularly section 249, it says that once there's a foreign judgment against somebody, particularly criminal conviction, you must bring that judgment to court under a certificate. It is that certificate that is admitted in court for it to be enforceable, for it to have force of law against that person. So in this case now, the judgment was not the judgment was not properly certified. It is not admissible for the court to even litigate upon. That's just the law. That's why election matters are sui generis.
Right. There were mentions, I'm trying to find the exact paragraph, but I can't quite get it, of the Senior Advocate of Nigeria, Olani Pekun, making statements about if the court interpreted things in a certain way, it could lead to chaos. I'd like to get your thoughts on that and how people interpreted it. Was that in any way close to his intention? Do you think?
No, I'm not in the man's mind.
But with his words, at least.
I cannot dive into his mind and know what is it, you know. But what is stated here, if his intention is to mean that if his candidate is not declared the winner of the election, it will lead to chaos, you know, anarchy. I respectfully disagree with the learned Sikh. I respectfully, because the law is the law. If the court finds out that the person so nominated by APC is not qualified ab initio, you know, the court will declare the vote, the over 9 million vote casted for him, as a wasted vote. But if the learned Sikh, who has been a Sikh since 1991, what it means that he does not want anarchy of the law. He does not want the law to cause confusion among people. That means it's on the right track. That he is saying that this law, uphold this law, this is the proper law that reflects the wills and the intention of the people. So it's of two sides. But if it means that, no, I disagree with him. If it means that it's to allow consistency with in our laws, which I agree, I think he is right on track. But in my own view, I think the guy is, as a Nigerian citizen, CFRO, it will not mean to cause chaos in Nigeria. But people have a way of distorting facts, you know, to suit their own belief. So I don't think the SN is making something, maybe deliberations aiming at creating chaos, anarchy in the country.
Right. I think that's fair enough. I believe I saw, you know, one of my colleagues, a fellow journalist, senior journalist, a veteran, breaking it down and saying that he just meant confusion in terms of the way people interpret the law. But
that's what I said.
Yes,
people like to distort facts, blow things out of proportion to suit their belief. You know,
this is why we really hope that we can have very direct, straight answers. You know, because you know, people always accuse persons of your profession of being able to maneuver and, you know, maneuverable. People are very scared of lawyers, you know, they say there's nothing they can't.
That's that, like I always say, one of the fulcrum of the argument of APC is that whether the non-transmission of results, does it change the votes from ECA theory?
You know, the PDP was saying that due to issues with the transmission, the 21 states ended up being 12 states.
If they can prove that, so be it. If they can, because I just say that once in law, once it's declarative relief, you must lay strong evidence. Even though the other parties don't even bring evidence at all. But for court to grant you, you must lay the evidence. How convincing and cogent is your
beyond reasonable doubts?
When you allege something of that nature, it appears to be quasi-criminal. You must prove it that INEC, you know, disingenuously, you know, converted your vote and allocated it to the party declared as winner.
Right, that's fair enough. Now let's look at, you know, the final one from the Labour Party.
Okay, sir.
something is interesting about this, which I think a lot of people started to point out, is that if I take a look at at it myself, I'm not sure that in any part of this address, Peter Obi asked to be declared the president. I mean, I've gone through it and I've seen others comment on it also. It was more a thing of disqualify the president, sack the president. He's not the rightful one. But people wonder, the fact, because Atiku on the other hand actually asked to be declared the president. So people wonder, the fact that that stipulation is not there, is it an indication that perhaps the Labour Party candidate thinks he did not win and is just simply trying to disqualify the person he feels also did not win?
There are many prayers before a tribunal or a court of law. Sometimes lawyers like to fish. It's like fishing. You throw so many prayers up front. You pray that the court take all or take some. In every way, anyone the court takes is in your advantage. It is in your advantage, and it's disadvantageous to the other party. You understand? Labour Party in the alternative prayer, they are saying they should declare him as the winner of the election. The other way, they are saying disqualify this person and let two of us, Atiku and Peter Obi, go for a rerun. These are clear case of fishing, and it's what lawyers do. It's what I do. It's what almost every lawyers in the world do. Lawyers brings in catalog of problems, catalogs of offer solution, catalog of relief, and pray that the court grant all or grant some, anyhow it is.
Right. I just want to quickly bring in an old case here. I'm not really sure how, but you definitely know about it. The Imo State issue, where Governor Hope Uzodinma ended up declared. People usually reference that and they say that's what Peter Obi is trying for. That Governor Hope Uzodinma went from a 4th place to winner, and that Peter Obi is trying to do the same from a 3rd place who they believe shouldn't be in the equation, trying to get that spot. I don't know if you can shed a little bit more light on what happened on the other aspect, because people think it's some kind of magic.
Of course, it's an abracadabra. It's hocus pocus now, called abracadabra. Somebody moved from 4th position to 4th position to the 1st position. So I'm still trying to figure out how the court arrived at their judgment. So maybe it will happen, but I think that judgment was in pencuriam. Pencuriam means that the judgment was perversely reached. That means it was an incorrect judgment against the evidence that was adduced before the Honorable Court. That's to my mind, to my legal mind. Maybe for what I also heard, they said that the other party, the INEC, the allegations or the averments, sorry to use the word, that is like the facts, what they are saying, their view about the matter, they led before the Honorable Court. APC never contravened that, PDP never contravened those facts. So it's like fact not contradicted is deemed admitted. That was the ratio of that judgment. So in this case now, I don't know whether APC or Tinubu serially, disagree with all the averments in Peter Obi or PDP's petition.
That's fair enough. I'd just like to know now, what do you think this will, at the end of the day, do for the judiciary in terms of broadening? I think the word is jurisprudence.
That's
what do you think? How do you think this will turn out?
No matter how the judgment goes, whether it's in favor of Tinubu, whether it's in favor of Peter Obi, or whether it's in favor of Atiku, it goes further to broaden Nigeria legal electoral jurisprudence. It enriches it with more cases on how to decide matters, decide facts, election matters on points of law, especially when we just have the new enacted Electoral Act 2022. That's what it will do. It will just broaden the Nigeria electoral jurisprudence. It will enrich it. That's what it will do. But in any way, Nigeria should be happy. It's not easy for Nigeria to conduct election. We have conducted election. There's peace. We are moving on. That's what Nigeria should be happy. Irrespective of how it goes, Nigeria should just be happy. because democracy is the best form of government. The worst democracy is better than the best form of military government. Nigeria should be happy.
Yes, I think that's an interesting way to put it. But I just like to know, in terms of rule of law, good governance, and the role of citizens.
Yeah.
Whenever all these things are settled, I believe I think I got that quote from you where it says the court is not final because it is infallible. It's infallible because it's final.
Adejoke motus. That was Justice Oputa's dictum.
Wow. So that being said, when these things have happened, it means there's a finality to it.
Of course.
Move on with your life.
Yeah.
But I'd just like to know, what do you think is the role of the average or the common man in terms of seeking redress? It doesn't have to be particularly with maybe political issues. I'm sure you're aware of some of the recent developments, fuel being 617, this one and that one. Can the average man, do something about that, legally speaking? Because some people are saying, if you voted Tinubu, we don't want to hear you talk, we don't want to hear anything. If you voted so person, he was going to do the same. But I just wonder, if someone just feels, I've had enough, what is there a legal way they can do something about it?
Yes, this is one of the lacunas, the lacuna in our Nigeria constitution. Sometimes Nigerians feel aggrieved. In Nigeria feel aggrieved. They want to correct an inadequacy in the society. But he's circumscribed because the constitution says things like that have to do with amenities, education, even though it's stipulated in the constitution as one of the responsibility of a government. But the constitution also inhibits you from bringing an action. They will say it's not justiciable. When somebody bringing, maybe the government fails to provide light in the environment, and you bring forth that action before the honorable court, they will still raise the constitutional principle, as the constitutional section that says such actions is not justiciable in court. That is one of the places we need to correct. We need to amend under section 9 of the constitution. We need to amend so that this basic need of Nigeria will be justiciable in the constitution. So no matter how Nigeria feel agree, even though the best thing is to go to court and let the court decide. That is where you cannot resolve into fisticuff or into anarchy. That will be more brutal, even more witty than what you are complaining against, because they will charge you for treason or civil disturbance or conduct likely to breach public peace under the criminal code or under the penal code.
That's interesting. So let's just relate this a little bit to some of the happenings we've been seeing recently. And after the court has said something, when the executive is not will I say playing his role or meeting up with his own end of the bargain, what now happens then? I'll do some instances. Take for instance the CBN governor's issue. I don't know to what extent that might have violated any laws, but I believe there's a period of time you're allowed to hold someone before either charge them or let them go, and so on and so forth. And that's one. We had issues where I believe on 2 occasions the courts ordered, is it the remanding of the IGP, and also another one was the EFCC boss at the time. And a lot of Nigerians just looked at that story and said, the IGP, who's going to take the IGP there?
Who's going to police the police?
Yes, exactly. So in these regards, how do we start? And then there are also numerous court judgments that I've personally
disobeyed.
Yes, and I've spoken to people who have had judgments in their favor, where the court says, pay this person so amounts in damages.
Actually, government institution.
Yes, what's the way forward there?
Like I always say, disobedience to court order is a recipe for anarchy. You must look at it. It's just Nigeria may not be a sane country that have respect for the rule of law. Once a court have decided a matter, the federal government is circumscribed. is inhibited from disobeying or going against that law, they must respect that law. No matter how condemned a court judgment is, obey before complaining. If you don't like it, you simply appeal. There have been galaxies of events where Nigeria government or federal government have disobeyed court orders. It's not good for democracy. One of the fundamentals of democracy is the rule of law. The rule of law, maybe the other one is separation of power, but rule of law is the foundation of democracy. Rule of law, allow the law to prevail. Once issues are submitted to the judiciary, bow before the decision that is taken by that honorable court. That's just my own. Federal government should learn how to obey court order, because if the court have decided, I don't know whether you must have heard this notorious case of government of Lagos State against Ojukwu. The case is so notorious on the need for Nigeria to obey, on the need for governments to follow the rule of law and obey court order. That locus classicus is so important in Nigeria legal jurisprudence, on the need for governments to obey court orders.
All right, thank you so much. It's been great having you on. The way you break down things, it makes it accessible to the average person out there. Thank you so much.
No, thank you very much. It's my pleasure to be on KAFTAN TV. I'm always happy, to be on KAFTAN. It's my pleasure. Thank you very much.
Thank you so much. All right, that's all we take on the program for today. Don't forget the POLITY reaches you from Abuja every weekday, 2 p.m. to 3:30 p.m. Do join us tomorrow for another edition. Promises to be as interesting. See you tomorrow. I'm Amadin Ubewe. Bye for now.